the DRJS, the Division of Racial Justice Statistics, within the Office of Racial Equity. We've got a bunch of folks from DRJS who are joining us here. So that's part of the reason we get the update from the Advisory Council, is so that we are well tied into the data collection world. I don't know, am I capturing enough there?
Yeah,
Do folks have anything to add? Anyone from DRGS or otherwise, JS or otherwise?
Thank you, Todd. I just wanted to make sure I was understanding it right. Thanks.
Helpful question. Nothing, Laura?
I have some thoughts, but I think what I will do is share our annual report. That is, Grace mentioned briefly the functional analysis and gap analysis, which is largely what our annual report is about. So I will just put that in the chat.
Terrific. I think that wraps up that update. We were going to talk, and Susanna, I turn it over to you if you want to start facilitating.
Thank you. I don't know why. I never leave the office at the correct time, so I apologize to all of you for repeatedly, chronically offending on this. Okay, so we are at legislative proposal. Oh no, God help me out. Is this back? Is it me or is it back to you?
Well, I realize what I copied from is not what actually. There's an inconsistency. It's supposed to be you, me, and Rebecca talking about this, and it's a discussion, not an update. So I don't know. I think I pulled an old version when I was just pulling up a Word document here. But I'm happy to see it. Yeah, go for it.
So the panel will remember that we had been tracking a recommendation that came out of this panel's work around use of an impact assessment tool, and that was proposed as legislation by Representative Arsenault. And since then, there have been some internal conversations with the Legislative Council advising on a course of action for that proposal. So, yeah.
And I'm happy to, so essentially what Leg Council said, so just structurally, the legislature has their own lawyers. They are called Legislative Council. They are the folks who advise the legislature. They draft the legislation. And so we submitted our proposal through Representative Arsenault, and Legislative Council's response was that generally the practice within the legislature is not using statutes to control how the legislature moves through its legislative process, that they use rules for that. Rules are different in that rules are approved every year by every successive legislature. They can be changed by that legislature, and they don't go through like a bicameral system, you know, House, Senate, and then get signed or not by the governor. It's House by House, chamber by chamber. And so Legislative Council's take was, hey, listen, this is really a proposal that should be a rule proposal, not a legislative proposal. And we've been working to sit down, and just because the legislature has been very full, the meeting where we were going to sit down with Leg Council and the clerk of the House, who kind of keeps the rules as they are, is this Friday afternoon. Happy to invite other folks to that if they want to. And I think the issue and the concern, well, I don't want to speak for you, Rebecca, but Rebecca has raised, I think in the last meeting as well, sort of reiterated is, you know, statute is structurally potentially much more durable than the rules, because the rules can change session to session or biennium to biennium. And so just wanted to have a little bit more conversation if there are elements that we want to take into that conversation with the legislature and Legislative Council, I should say with the representatives and Legislative Council and the clerk of the House this Friday. And let me hand it over to you, Rebecca.
Yeah, thanks, Todd. And again, just as further background, because I forget, it is really confusing how the legislature works in terms of the bill and lawmaking process. And I think what happened and what Todd and Susanna were talking and sharing is that Representative Arsenault reached out to the three of us after we passed this recommendation on behalf of RDAP because she wanted to share this idea that Legislative Council had thought of when she or he, I think it's had seen this come on her desk to draft it into a bill that it struck her that it was more suited for a rule. And so a meeting was planned to get our thoughts on it. And I couldn't make the meeting, I think that is set for Friday, but I did want to share with the group, with that smaller group, that I was concerned because I thought that was actually a very substantive change that I wanted to have brought forward to the panel, to have panel members weigh in. And I was concerned because I see a fundamental difference between a law and a rule, right? In terms of how it becomes its final form and the permanency of it. My concern about a rule is that it's temporary, inherently temporary, and is subject to suspension. And so we spent a lot of time on it, and there are other states out there that have this exact, well, not exact, but this concept of an equity tool assessment legislative scheme passed as legislation. And so that's why we're here and we have it on the agenda. I asked that we get the panel members to weigh in if people had thoughts on it, questions about it ahead of the Friday meeting. I think, Todd, that's the plan, is there's a Friday meeting?
Yeah, and I think whoever can make it to that will come back and report to RDAP on kind of where things head with that. Are there other comments, concerns, questions on that? It looks like we lost Susanna, or my eyes can't find her on the screen. Nope, you're right there. You're like right next to me. That's why. Sorry.
So I'm jumping back in because it's still quiet. And I just want to make sure I was clear. I, as a panel member, thought that this was of interest. If panel members are not caring or ambivalent about whether or not the proposal goes forward as proposed legislation or in rule form, that's fair, or otherwise to weigh in and share an opinion or ask questions. But I wanted to give some space on our agenda tonight to have the panel weigh in.
Hi, Rebecca. Thank you for that. So let me make sure I've got Sheila, her panel member. What I think I hear you saying is the difference between law and rule and how those differences can be extremely impactful to the work that we're doing. And it sounds as though we want things to go through the legislature to make it into law and not just be a rule, so that it can have much more clout base to what we're doing. Is that the discussion we're having?
Sheila, hi, it's Rebecca again. I think that is the discussion we're having. It's not necessarily the only way to frame it. I think that there's part of what hasn't been put to words yet is it easier to get this idea pushed forward sooner rather than later? Is it, I don't, how easy is it to get a rule passed as opposed to legislation? Is it, it certainly is beyond our ability to control, but to the extent this panel wants to weigh in as to what we would like, I think that there would be interest in hearing the panel members' perspectives.
I don't know if it's just me, but maybe it's like I need like a visual, like side by side, like okay, you know, the law versus the rule, the timing versus if we did this, it'd be this. So I guess that's where I'm a little bit, and I don't know if other people might be hesitant to comment, but for me, I'm trying to understand the full differences in each to understand why it would matter to go either way, or because I'm a person who's just like, I'm a person who's like, let's go for it. I'm like, let's go for law, you know, let's not do this whole rule thing, whatever. However, we're talking about strategy, we're talking about time, we're talking about other factors. And so I don't understand those other factors in the conversation enough to be able to have an intelligent conversation. I guess is what is just where I'm at. And maybe I missed something, but I again rather go through the legislature, understanding that I'd love to hear other people's comments of understanding strategically why would we go more understanding rule or going a different route than just going forth and doing what we need to do.
Mia, I see you with a hand, Jeff. Go for it.
And pardon me if this was already articulated, but I think I just need a little bit of more clarification on the specific recommendation we're trying to either get passed either by law or rule in the first place. Can you articulate that particular recommendation a little bit for me again, so that I can understand if there's urgency or whatever, so we can make a better decision?
Yeah, so this is a proposal to have the legislature use an impact assessment tool whenever it is proposing new legislation and method and the bill in particular, the bill that was proposed or that is being the in question, the bill draft in question, would have created a temporary working group to figure out what kind of a tool to use and how best to get it implemented. So it would give some runway to being able to craft what it looks like without that having to be specified in the law. Derek?
One of the things that I hear about the difference is, at least my interpretation, is that when it's legislated, it becomes an ideological statement. Like, we believe that this should be an affirmative right that everybody has to have legislation that's been intentionally put through this process, as opposed to a more transactional process that, like, I feel like a rule represents. Um, and so that part of me feels more committed to the legislative route. But one thing I don't profess to have any understanding, and I would be interested in any and all takes on this, is recognizing that rules seem like they are more easily changed than laws, right? Laws are not necessarily permanent either. How often is it the case, in anyone's experience, maybe Todd, you've got some perspective on this, that rules once adopted really become subject for, changing or removing? Is that a frequent occurrence? What's the volatility profile of a rule?
I'm happy to take a stab at that if that's all right. So I'm actually in Sheila's boat on this. I think what would be really helpful and what I hope to get from our meeting on Friday is like the side-by-side chart that we can share out and really talk through, not quite a pro-con, but like what's the timing on a rule? How does a rule pass versus legislation? So by way of example, a very easy or relatively well-known rule in legislation is the filibuster in the Senate, the U.S. Senate, right? That's a rule. It's not a law. It's not a constitutional provision. That's an agreement that the Senate has had for, can't remember if it's 100 years or more. And and we've watched in the last 20 years that rule get reduced by whichever party's in the majority over and over and over again. We can have our different opinions on whether the filibuster is an anti-democratic tool or not, but by way of example, right, in the 80s, it was all legislation, 60 votes for cloture, and then it could move to a regular vote. And in fact, you had to physically filibuster. We've seen that change over time. So that's an example, and to Rebecca's additional point, rules can be suspended in a way that statutes can't be. So I think this conversation is, I think, largely about educating us as a group about what's potentially before us, though to Rebecca's additional point, it's not really our call at the end of the day. But I think our advocacy can help ideally push in a certain direction, and it seems as though it'll be helpful. Again, for me, it sounded like maybe for others as well, to really hear what the different paths look like. And this is a structural thing that we can talk about as well, maybe in the next segment of the agenda, and maybe later is, and that means waiting until March 10th to have that conversation. Potentially.
I would like a side-by-side too, to know better, but also, like, where does accountability fall in a rule versus a law? And how is that measured, and how is it taken? Because this seems like an actual request to do something. And so does the rule sort of stand up to an accountability process better or worse than a law? And I think that's a priority for me in all ways, is like sort of holding accountability at the front of this before making a decision.
Rebecca, go for it.
Yeah, it sounds like it's going to be a to be continued discussion. I'll just share this because fundamentally, what I do understand about the legislative procedural rule is that it's each chamber, the House of Representatives and the Senate, vote at the beginning of each biennium. Right. So I don't think it's every year. Maybe you can add some additional rules. I'm not sure about that. But generally, you adopt a set of rules at the beginning of each biennium, but each chamber adopts their own set. Right. So the proposal or suggestion here is that if this equity assessment tool that RDAP passed and put in our report and submitted to the legislature just in January of last month, if it were to be treated like a rule, in effect, it would have to be adopted by the next biennium, by the House of Representatives, and also separately by the Senate. The committees then would be, of each chamber, would be subject to these procedural rules adopted by each chamber. But again, those committees can suspend the application of the rules. So in terms of consistency, transparency, I'm not sure how we know. I mean, I'm sure there's something on the record when a rule is suspended. In terms of making sure it's consistently applied to each committee, to me, that is the red flag, and why I saw this as concerning, because to me, this is where it starts to become like Swiss cheese. And then there is the end date. At the end of the biennium, whatever rule was adopted by whatever chamber and applied by whatever level of consistency by each committee within each chamber goes away. There was a question as to whether rules come back because they're so common or not. Todd talked about filibuster. We know that there isn't anything like this. So there's no historical precedent to see whether Vermont will come back to this. Anyways, so that's that. So, and certainly laws can have sunsets built in at the very beginning so that they will terminate within a fixed period of time, which will often happen if there's sort of a big rollout of a proposed new change to sort of test the waters. So that it could be that it's a short-lived thing too. The terms of the legislation could be such that it is narrower. it only applies to certain things. We don't know what the proposed bill will be like yet. Anyways, I'll stop there.
Your thoughts on this, or is there anybody else who might be interested in joining on Friday or weighing in maybe after they've had some time to think more about the possibilities?
When is the meeting? Like what time and like logistical details?
I think the latest, it was going to be at 4. I think now it's trying to be pushed back to 2:30 or 3 o'clock on Friday. Virtual meeting, or a virtual option in the meeting. I would also offer that I've been writing down accountability, timing, suspension, avoidance, process, challenges, consistent application, some of the themes that I'm hearing from folks, so that I've got like some questions to ask and some clarity to get. And I would just invite, if folks want to send me emails about that, I'm happy to just gather that information up so I can, I guess it's me, come back and report on the conversation, this upcoming conversation at RDAP, and hopefully answer as many questions as we can on this.
Hi, this is Karen. Can you all hear me?
We can hear you.
Okay, thanks. I'm driving in this lovely snowstorm, so I'm probably not going to weigh in too much, but I just had a question because I wanted to make sure I understood this correctly. Is an option on the table that this could be a legislative study or work group of sorts?
Not something we've
Hello?
offered. Yeah, sorry, Karen. Not something we've offered, in part because the legislation hasn't been, to my knowledge, drafted.
Oh, I see. Okay. All right. I was putting the cart ahead of the horse. I just wasn't sure if that was something being considered. Thank you. I just was wondering about that. And I'm appreciating the conversation, and I don't know that I would have any questions to add to the good ones that have already been put on the table.
So if everyone is okay, we can maybe move to the next item, which also is related, which is a recap of the testimony that we gave on behalf of the panel a couple of weeks ago. So you all will recall, Senate Judiciary invited the panel to provide testimony, just an update on our stuff in general. So I appeared with Todd and we said the following. Hey guys, long time. How are you? We give you a report. Here's what it says. We made it a point to be very clear about what this group agreed on. I know that at our last meeting, we had a lot of discussion about re-upping and renewing recommendations and whether they were consensus and not. And I choose to believe that we made the point accurately and fairly that represents the group and its various appointing authorities' positions on things. We also told them that structurally or organizationally, we have a slew of new members. New members, I apologize, we did name you, so I hope that's okay. And talked about the great knowledge and experience that they're contributing to the group, and also did share with them that we are still without a chairperson, but hoping to turn a page on that chapter soon. And we gave them a short list of bills that this group has expressed interest in recent months, and said that these are all bills that are relevant to their work, so that they should consider us for potential input. And I have that list that I gave them written down on a piece of paper in a different room than the room that I'm currently in, so I can tell you which ones they were. but there's stuff that you all said you cared about, so I didn't go off the whim and say something else. And Todd, what else am I missing?
Nothing to add, which is basically what my testimony was.
Lisa.
Yeah, I was able to watch the testimony live, so I just wanted to express gratitude to Susanna and Todd for their testimony. It was really well done. Thank you for representing RDAP.
Thanks, Lisa. All right. Well, flowing very, very nicely. Our next agenda item is, thank you so much, because I was switching back and forth between that and a different program. It was painful. Our next agenda item is a quick rundown of what's going on right now legislatively that's relevant to this group. Laura, I'm going to ask if you wouldn't mind just giving us a quick rundown of stuff that's moving. If there's any updates on those things since last month.
Yeah, so Jeffrey and I put together a presentation. So I don't know if for the new folks, I guess we should introduce ourselves, and then I'm going to turn my camera off. And then I think, Todd, you'll have to give me sharing powers. But for those of you who don't know me, my name is Laura Carter. I'm an analyst in the Division of Racial Justice Statistics, which is in the Office of Racial Equity. And I'll turn it over to my new colleague, Jeffrey, to introduce himself.
Hi, I'm Jeffrey, and I am a policy and research analyst.
Thanks. Okay. I'm going to turn my camera off and then try and share my screen, which I can do. Okay, I know I need to do this. Okay. So I will say we did include the bills that we talked about as kind of a recap at the end. Some of them that we're going to cover tonight are a little different. And I promise I'll send this out as a PDF once the meeting is over. So these are just some bills. We're going to cover the criminal legal bills first. And so this is a really big list. I'm just going to point out the ones that we have equity concerns, because in the next slides, I'll read the titles. You'll see the titles again of the bills. So the first one is S193, which is about creating a forensic facility. Also H529 related to enforcing violations of pretrial supervision conditions. H550, which is about gender equity within correctional facilities. The equity concern there is if they combine language from a different bill, which again, I'll talk about when we move forward. And then the other one is, H741 requiring the court to issue an arrest warrant when someone fails to appear in court. So some of these we did talk about last month. S208 is one of those, which is an act relating to standards for law enforcement identification. So this requires law enforcement officers to identify themselves in various methods, either by announcing themselves, having a visible badge, etc. It prohibits face coverings with some exceptions. It also added the VCJC to create a model policy regarding or training regarding how law enforcement officers are supposed to do this. So the committee recently voted version 4.1 out of committee with an amendment unanimous passing 5-0-0. S209 is an act relating to prohibiting civil arrests in sensitive locations. And so this adds to where civil arrests cannot take place and what a sensitive location is. This includes government buildings, schools, community-based or emergency shelters, healthcare facilities, and more. The list is very, very comprehensive, and I know the committee had a lot of discussion about what a school could be considered, or any kind of place where there could be children. And this was recently voted version 2.1 out of committee, Senate Judiciary, again with an amendment and a unanimous passing of 5-0-0. So S193 is an act relating to establishing a forensic facility for certain criminal justice involved persons. This is one of the ones that I had flagged for equity concerns. This creates a forensic facility under DOC custody. These individuals would be eligible for placement in this facility if they are not considered competent to stand trial, and it requires the individual to have their competency restored in order to be released. There is an adjacent bill in my opinion, in House Judiciary right now, H 627, which regards the rights to crime victims in these cases, but the bills are slightly different. And we don't cover 627, but I can send more information if folks are interested. So far, we've heard testimony from the Secretary's office at the Agency of Human Services, the General Counsel from the Department of Mental Health, and the Commissioner, and also General Counsel from the Department of Corrections. There's going to be additional testimony from the state's attorneys and sheriffs and the judiciary. Equity concern here, big flag, is that an individual basically can be held there indefinitely based on how the bill is written at this time, because you can only be released once you're competent to stand trial. And we know that some folks in some situations may never have their competency restored. So the next bill we have is H294, an act relating to commissary and telecommunication prices in state correctional facilities and fair compensation for incarcerated labor. It requires the Department of Corrections to review private contracts for commissary and telecommunication services that are currently provided in correctional facilities. It updates these to be free for incarcerated individuals. Currently, they have to pay to make phone calls or have video messaging. And it also requires an increase in wages performed by the incarcerated population. Most recent testimony from the DOC business office, or the financial managers, indicated that the hourly rate, depending on your position as an incarcerated individual, ranges from 25 cents to $1.25 an hour, with the median earning is 65 cents. So this would require them to do at least the state minimum wage. And then there'll be upcoming testimony this week from the Prison Policy Initiative, and also additionally from DOC. Sorry, I need to take a sip of water. Okay. So H529, an act relating to enforcing violations of court-imposed pretrial supervision conditions. So this is the Committee of Jurisdiction is currently House Judiciary, and there will be testimony later this week. This adds pretrial supervision officers' ability to review conditions that constitute a violation of conditions. And we'll hopefully hear upcoming testimony from the Council of State Governments, the Department of Corrections, states attorneys and sheriffs, and the Office of the Defender General, and the judiciary. The next bill we have is H549, an act relating to eligibility of detainees to obtain state-issued non-driver identification cards. So this expands the non-driver state-issue ID program to detainees. Currently, it is only available for those who are incarcerated, and you have to be incarcerated for at least 6 months. I believe the same time frame would be applied to detainees. The Committee of Jurisdiction is House Corrections and Institutions, and they're currently coordinating with the DMV Legislative Council to ensure consistency across the laws, because currently there are some components that may end up in a miscellaneous DMV bill that contradicts some of the existing legislation about the DMV DOC ID program. So the committee's heard testimony from the DMV and also from the Department of Corrections, and there'll be more testimony from those same agencies. H550, an act relating to gender equity within Vermont's correctional facilities. So the intent of the bill is to align DOC policy and procedure better with up-to-date mental and medical health care for gender transition and recognition. The discussion, this is where the equity concern is, the discussion to expand the bill includes components of the House Correction Bill H32, which is regarding continuity of care for the opioid use disorder, or for folks who have opioid use disorder. And there's some language in that bill that's kind of ambiguous that could result in disparate impacts. So if they were to add that into this bill, that would be a concern for us. So far, they've only heard testimony from an individual with lived experience. This is a person who actually underwent their transition while being in the custody of the Department of Corrections. It was a really powerful testimony. And they will be having upcoming testimony likely from the Department of Corrections, specifically related to the Prison Rape Elimination Act, and likely WellPath, which is the Department of Corrections healthcare vendor. Okay, H559, an act relating to the parole board. So this changes the number of individuals on the parole board. It clarifies term limits and adds training components. We feel this could be expanded to include new types of parole for those currently in DOC custody. However, this is a really great change to increase the number of members on the board. Currently, it is in House Corrections and Institution, and they're on bill version 1.1. They've heard testimony from the parole board, the Attorney General's office, and the Department of Corrections, and then they'll be having additional testimony from the Secretary's office at the Agency of Human Services and also DOC. So this is my last slide, and then you won't have to hear me talk for a little bit. This next bill is H635, an act relating to eliminating Department of Corrections supervisory fees. So this eliminates all supervision fees, and it requires the department to forgive all outstanding supervisory fees and stop collecting supervisory fees basically immediately. Prior testimony indicated that there's roughly $350,000 collected in fees per year. So one of the questions really was, where does that money come from to fill the gap of the supervisory fees? So they've heard testimony primarily from the business office of the DOC. They voted version 1.1 out of House Corrections with the unanimous passing of 11-0-0. And now it's going to be headed, that was literally today, this afternoon, it's headed towards House Ways and Means or potentially the Appropriation Committees next. H741 is an act relating to the court, an act relating to requiring the court to issue an arrest warrant when a criminal defendant fails to appear in court. Currently, this is in the Committee of Jurisdiction is House Judiciary, and there will be testimony on this this Thursday. It adds issuable arrest warrants if someone fails to appear in court after being released, regardless of if you bail conditions, bail or no bail. And then lastly, I just want to say thank you to Rebecca Turner for flagging this one for us. This has come up in conversation in this committee and also in the RJSAC. It's H828, an act relating to banning the transfer of military-grade weapons to state, county, and local law enforcement agencies. The Committee of Jurisdiction is currently House Gov Ops, and it's a short-form bill. There hasn't been any testimony on this yet. I was unable to connect with Falco from the ACLU, but the intent language includes basically prohibiting the transfer of military-grade weapons from the Department of Defense, Armed Forces, or any federal agencies to any of the state, county, or local law enforcement agencies in Vermont. And so I'm going to turn this over now to Jeffrey, and just let me know when you need me to move the slides.
All right, can you hear me?
Yes.
All right, perfect. Yes, so on my end, there are a few bills that I am keeping my eyes on. These are the current 5 that I am keeping my eyes on, and also in consideration of any equity concerns that we might have. Move on to the next slide. The S23 is a bill that's aimed to limit impact of AI generated deep fakes in political campaigns. The bill requires that within 90 days of election, any deceptive synthetic media includes a clear disclosure stating it was created or altered using AI or digital technology. Any violations to this could trigger civil penalties, and depending on the candidate, may seek court injunctions to stop dissemination. The bill includes important exemptions for satire and parody, legislative news organizations, telecom communication providers. The severity equity concerns that I see in this is ordinary citizens may unknowingly share AI generated content and still face legal risk due to ambiguity in the unknowing share exemption. Smaller campaigns lack the technical and legal resources available to well-funded candidates. Communities with lower digital literacy face increased exposure to deception while also being more vulnerable to accidental violations. Enforcement of satire versus deception standard may be uneven across political and cultural exemptions and marginalized candidates, particularly women, people of color, and so forth. S176 and H739. These are new bills that were brought to my attention yesterday, actually. They're currently housed with the Agriculture Committee. This is to ban all paraquat, a highly toxic herbicide that is currently banned in more than 70 countries due to its strong links to Parkinson's disease. Why is this on my radar? It's on my radar because due to the farm workers. In 2024, Migrant Justice did a survey where over 80% of migrant workers reported having some sort of chemical health related issues. So this is a bill that we're currently looking at. And this morning, I received word that House 739 may not pass due to two reps, Representative Lipsky and Representative O'Brien have not yet made the decisions yet. Due to that, if they're not able to make this bill a priority, then it would die, and we can continue to see a use of this toxin use in our counties. And currently, Anderson County has reported to have the highest count of using paraquat. The next bill, the genetic data privacy, is response to growing concerns about genetic data privacy by placing new restrictions on direct-to-consumer genetic testing companies operating in Vermont. The bill requires companies to obtain explicit consumer consent before transferring genetic data outside of the US and ban the storage of Vermonters' genetic information in countries sanctioned by Office of Foreign Asset Control. This bill is currently housed in the Commerce of Economic Development Committee. As far as I know, there's only been one initial testimony from the Attorney General Office. And the equity consideration are centered to the discussion. Advocates have raised concern about unequal access to genetic testing services and highlight risk that marginalized communities face if genetic data is misused or breached without robust safeguards. Genetic information could be used in discriminatory ways, particularly affecting communities that already experience disparities in healthcare, employment, insurance, underscoring the importance of the strong privacy and enforcement provision in the full bill. The last bill was also brought to me, the H742 Immigration Legal Defense Fund. Addresses a major gap in legal protection by establishing a state fund program to provide legal representation for Vermont resident detained in federal immigration proceeding. Because violations are handled under civil law, detained individuals currently have no right to government-funded counsel, forcing many to navigate complex and high task federal process on their own. This was introduced January of this year. The bill is now before the House of Judiciary Committee and process creating to determine the fund to support access to qualified legal services. The legislation is grounded in strong evidence showing that legal representation dramatically improves outcome in immigration cases, including high asylum approval rates and shortened detention periods. As this bill advances, lawmakers are expected to examine its fiscal impact, administrative structure, and the appropriate role of the state in supporting residents facing federal immigration enforcement. The proposal may also be expanded to clarify eligibility standard and identify sustainable funding mechanism to ensure the program effectiveness and reach.
Good, Jeffrey?
Yes, that is all.
Okay, awesome. Thank you. These are just some quick additional movements and general updates. So these two bills that are on the left came in and then came out. So just quick updates on these. H566 is an act relating to sealing post-charge court diversion records upon successful completion. Version 3.2 was voted out of the House Judiciary Committee with a 10-0-1 vote, and it is currently in Ways and Means. This is primarily just updating language from expungement to sealing based on legislation that was passed in 2025. And then we also have H572, an act relating to permitting public access to electronic criminal case records. This recently just popped up on my radar. I know they're in version bill 1.1 right now, and I'm reviewing testimony. According to the legislative website, there's been quite a bit, but it only just popped up on the schedule last week. So I could have missed things from 2025. Anyway, and then also we thought that it may be in the committee's interest or the panel's interest. There's a joint hearing between House Judiciary and Senate Judiciary tomorrow on the state of public safety and the Chittenden County pilots, so the accountability courts and those things. And there'll be some testifying agencies, which include the state's attorney's office, the Office of the Defender General, the Judiciary, Corrections, and also the Governor's General Counsel will be there as well. And that's it. And then those were the bills we covered in January. You're muted, Susanna.
Am I here? Do I exist?
Mhm.
Okay. I'm not supposed to hear that part. What I was saying was questions, comments, complaints, concerns on anything we heard from Jeffrey and Laura. Yeah, Rebecca, go for it.
Hi, quick question, because I know we have a full agenda, and thank you, Jeffrey and Laura. It's always really helpful for you to do that, and it's really tough to present that succinctly, so thank you. I am going to zero in, and here's the narrow question. Of the bills that you flagged had equity concerns, and of that narrow category, the ones that you see moving forward with testimony, can you say whether or not there has been testimony as to the equity concerns?
So I know, so the four that we flagged for equity concerns in the criminal legal space is S193, 529, 550, and 741. And I would say that no, that there has not been any testimony. I can say that the bill with the most testimony on it currently would be S193. And from what I have heard from the Department of Corrections and from the Department of Mental Health, it sounds like DOC is fully on board to do this. There's question about building a facility because that would be required based on this bill, and Department of Mental Health also seems on board as long as there is a program in place to restore competency, because that is a whole within this like care structure of care system of care in Vermont, according to Karen Barber, who's the general counsel of DMH. I think for us, the concern is that an understanding of co-occurring disorders and developmental disabilities that maybe do not have the ability to be restored for an individual, and that you are going to be in this facility or in this designated location until your competency is restored, because the intent is to stand trial, essentially. And that, to my knowledge, has not been addressed.
Yeah, and the bills that I flagged are currently still in their early stages. Some of them have not had any testimony yet, aside for the genetic data privacy.
Thank you. And I'll just share that that sort of fits the trend we saw last session and the session before.
To
I
try
wasn't
and
really- Hi, Susanna.
please go ahead, Sheila.
Oh, I was just curious a little bit more about I think it was 650 and 685, if they could be put back on the screen, because that's the only way that I can actually retain what was gone through. But I had just clarifying questions around them. Can somebody, either Jeffrey or thank you, Laura.
What numbers again, Sheila?
550 was one of them.
Okay, yeah,
Okay. So
sorry.
so what there was something about this that I had. Okay, so explain the you were talking about for the OUD, the continuing continuity of care and everything. Explain that a little bit more. I didn't understand that.
Yeah, so H32 was one of the bills that we talked about last month. Let me just pull up the title of this bill. But the intent of the bill is to basically anybody who is currently incarcerated within the under the custody of the Department of Corrections can opt into, they've renamed it. It used to be MAT, but now it's the MOUD program, which is the basically medically assisted treatment for folks who have opioid use disorders. So this bill essentially, I can't type and talk at the same time. Sorry, hold on one second. H32 is an act relating to treatment for opioid use disorder in correctional facilities. So part of this bill also expands care for continuity of care. So like if you're in the program and you're getting this medically assisted treatment and you're set to be released in 60 days, your case manager, your caseworker is coordinating with pharmacies or medical providers in the community to ensure that you're getting, I believe it's a 30-day prescription of this treatment, so that you're not just like released and immediately without any kind of care, but may still be you know, moving through that process. I can't find the words to say, but does that make sense?
Yes, I
Okay.
totally understand now. And then I think the other one was 685.
maybe 6:35. Hold on.
Sure. If you don't have a 685, then yeah.
Yeah, this is the one.
Yes. Can you talk more about supervisory fees? Is it, again, clarification? I don't know if I'm interpreting it
Yeah.
correctly
So,
or not. What is
so people,
supervisory fees?
yeah, of course. So people who are currently under supervision or probation and parole, I think more probation, are required to pay supervision fees to the Department of Corrections for just being on supervision by the department. So the current legislation is capped for $30, so you have to pay $30 to be under supervision. There is a waiver if you cannot pay that. I do anecdotally have heard from some POs that I used to know that most offices cap it at 15. However, the legislation does say up to 30. So this would eliminate that entirely. That would basically, this bill eliminates that entirely. So individuals are no longer paying essentially to be under the custody of the Department of Corrections.
That's pretty no-brainer.
Yeah.
Okay, thank you.
Any other questions?
Not right now, thank you.
Okay.
So wanting to stay ahead of these developments, if there's anything in this list, and I know it was a long list and we just kind of throw a wall of information at you, but if any of this stuck out to you and we as a group think that we might want the group's input on the record on any of these, it would probably be a good thing to check in on. I know a lot of you may be showing up and providing input or other testimony on behalf of your appointing entities, but just on a, do we think that this group wants to formally weigh in on anything that we've seen so far?
For me, it would be easier to just have sort of highlighted the ones that you see issues with equity and those particular issues noted. And then we can somehow, maybe if we can, I don't know, because I'm new, if we vote on that or we decide like how we come to a determination on how we support, or say we want to throw our name into the ring for supporting equity in those particular bills. So if I had just those ones that were concerns for y'all and what those concerns were, it would be more helpful for me to make a decision. We went through all of them, so like my mind is like I could dig into each of them. So that's where I'm coming from.
Totally. I think we try to balance it with what the panel has been interested in the past, and then other stuff too. But that's I did just send this to Susanna. I do think, just my personal opinion from watching these things for the division and for the office, that S193 is a major concern. So that would be out of the four, especially because that one has moved the most. But that's just my opinion.
Is it possible to have this conversation with the bills up on the screen so that we know what you're because I mean when you say S194 or 3, when you're saying these, I don't necessarily know what you're talking about, so it'd be helpful in the conversation. Thank you.
Rebecca?
Oh yeah, that's a big one.
Yeah, I was just gonna share, and for those new panel members who weren't here for last session, it's been a perennial problem for RDAP to have enough time to process the bills and then keep up with the changing amendments and then weigh in because of how we come at it representing different interests on this panel. Some of us are there individually, here individually, or they're in the legislature representing organizations. And in terms of up or down, in terms of the actual bill, what happened last year, and others can join if I'm calling this differently, but it's my suggestion as to going forward with these. And I'm hearing Laura as identifying S193 as the priority of the ones identified as having equity concerns moving forward. Is that be the RDAP's immediate communication to the relevant committees who have the bill, which is these have been flagged for us at our monthlies by the division as having equity concerns. We understand that there has been no testimony heard as to the equity concerns raised. We urge the committee to take or consider these equity concerns. And it sort of segues into this proposal of our report that we submitted in January, which is asking for legislation or rule an equity assessment tool as to all pending legislation.
Thanks, Rebecca. Other thoughts on this? Judge Tebow?
Good evening, everyone. I've had my camera off and suffer from really bad colds. I didn't think you wanted to watch me blowing my nose all night. But the one suggestion I had, and within the judiciary, we track and get updates on a lot of these bills from Judge Zone, who frequently is at the legislature. What I wanted to note was 193 is a really big one. I think that Laura has accurately summarized some of the due process concerns that are in there across the board, irrespective of someone's background. But there's definitely some work to be done on that bill. But what I wanted to highlight was the intersection of, I think, an area where there's a lot of verifiable data that this group has worked with, particularly with respect to bail, setting of conditions, and or maintaining bail. So I think it's 741, which deals with removal of the court's discretion to be able to issue cite and release warrants, would appear to me to be an area where there's a natural intersection between this group's work and the concern that there would be an increase, of course, and then cash bail coming into play in circumstances where prosecutors may not be asking for it and where judges may be disinclined to issue that. There's a lot of other practical concerns, I think, to go with that I'm sure other stakeholders could speak to, but that seems to be a natural one where there's a direct nexus with RDAP's mission.
So if this group is interested in weighing in on these items, one thing that we could do to be efficient is submit something in writing instead of waiting for the legislative calendar to come around to allowing for in-person or live, I should say, testimony. Obviously, there's a pro and a con to being able to address a committee versus to submit a document, but just thinking about timelines and about capacity of this group, if these are issues that we would like to weigh in on, then that is one option that we have. It occurs to me also in hearing about this that, and this is just a complete aside that we can put a pin in it for later, but I would love for our group eventually to have a sort of resource library that has maybe one-page issue briefs on each of these topics broadly so that members who maybe are less familiar with them, or any of us who may want a reference, could just go and say, okay, what is bail and who sets it and why does this matter? And just be able to read a 1 or 2 page summary. And it could be something that we collaboratively build, because thinking about an issue brief written by a public defender versus that same topic being discussed by, a judge or a prosecutor may have a different tone. But if there's maybe a resource library that we can all feel comfortable with, I think that could be a really good gift to future panel members. So I don't need an answer on that. It came up for me in thinking about, in hearing you all talk about the issues that you think we should address. Okay. So I've heard, and tell me if I've got this wrong, I think I heard 2 bills identified that people said the RDAP should say something about this. Right? 193 and Judge Chiba, it was 7, I know it's in the transcript, 741. Thank you, Chloe. So the thing is, if we're gonna speak on behalf of the group, I want to make sure that we have some sort of unified voice and some sort of agreement on what our stance is on that. I don't know that it'll be as easy as just, hey, one person here thinks this, so we're going to run with that. We could draft something basic written and send it to the group, and you all can provide us feedback individually, not in a reply all situation. Is that cumbersome? Is that going to be, are we doing the most?
No, I think that you're trying to come up with creative solutions to have us all be able to participate. So I'm with it. So I appreciate that. And while taking off some of the labor from us as well. So I want to recognize that. So I think they're great suggestions. I think there's lots of ways to get to the same outcome. So I do feel, I mean, part of the whole point of being on this committee is to use the power. I'm doing kind of quotes because once you're here long enough, you'll understand why. That we have on this committee to be able to lend our voice to people and say what we need to say. So I do think that we probably should have some type of voice and some type of unified voice, if possible, in addressing these. So, and I think that suggestion, I'm open to lots of different ways that we could do it. But I think that's great to as a starting point to be able to understand, and maybe we can engage in that discussion. I'm sort of wondering what the timeline is. And I also wanted to say that I think it's the last bill that was in regards to like federal weapons or something coming to local law enforcement agencies. That one in particular is feels very sort of urgenty in a way right now. And so I would love to discuss that as well. Not that all of them don't, but there's something about that with what is going on right now that I feel the need to discuss more in a timely manner. So those are my thoughts for now.
Karen.
Yeah, I just appreciating that we meet once a month and that everybody has a lot on their plates. I actually just wonder, as a group, if we could say we all share concerns on these 3 bills. I think it's S193, H741. I was on the phone for some of this, so I may have the numbers wrong. But I just wonder if we can say as a slate, these are bills that we share concern about. And so that way, if they really start to move, there's at least a way for us to jump into the fray to lend our voice to a process. So I don't know if that makes any sense, but that way we're not waiting to make a decision. And if a bill starts to move, we all could at least have a chance to weigh in over email. I would trust members of this group to be able to testify that we have a concern about a bill. I don't know if that makes sense, but it might just be a way for us to efficiently make a decision in a meeting that this is something we're going to be tracking, and that if it actually starts to move somewhere, that over email or an emergency meeting or something, that we opt in to lend our voice more specifically.
Good suggestion. Thank you, Karen. Lisa?
Yeah, actually, Karen, I love what you just said. I was actually kind of thinking along the same lines. I think written testimony is fine. But I think, if we let them know we have concerns with these on just an equity base, and then hopefully that would allow an invitation to testify or to provide testimony on said bills, which is what we haven't been asked to do in a long time. So I think that's actually a really fantastic idea and process to move forward with. Thanks, Karen.
Oh, Flor.
Yeah, thanks, Susanna. I agree with Lisa and Karen, and I'm wondering if it would be for us to set a legislative subcommittee that we could and that legislative subcommittee could also come up with some criteria on how we examine which bills are we going to look at, and then with that, potentially, then that legislative committee can, help us so that we can alleviate some of, not all the work falls on you, Susanna and Todd. It's just a thought.
Flor, I'm so glad that you said that because it, I think, moves nicely into the next thing that I was hoping we could talk about. In the chat, I'm going to share 2 screenshots. They are both from the survey that we conducted of this group last summer. And they highlight 2 questions specifically. The one I want to focus on, it hasn't landed to you yet because I still have the spinny wheel. But the one I wanted to focus on was the second one, which was the question that asked members, which standing subcommittees should this group consider having? Of course, standing subcommittees meaning they don't dissolve. And out of 9 respondents, 6 said a legislation committee. So I think if we redid this survey, we would probably have a similarly strong proportion of people who agree with that. And I wonder if this might be a good time to consider thinking about who might want to participate in something like that, who can quickly mobilize to draft something and get it out to the group. I'm seeing some nods and thumbs ups. Okay. So what I'll do is I will ask anybody who's interested in serving, even just for the next couple of weeks, on a startup legislation and policy subcommittee, please put your name in the chat, and then we can follow up with you with an email. Again, if you don't want to make a long-term commitment, that's okay. But if you at least want to help out with this one thing that we said we want to flag these bills for the legislature, then that would be a big help. Oh, I raised my hand and now Zoom thinks I'm raising my hand. I'm like when robots tell me how to feel. The second screenshot that I put in the chat was the question about what the group's leadership structure should look like. And I put it here just as a reminder because our last couple of agenda items, I think, touch on this a little bit, except now we have more members and new members. But the question asked, what should the leadership structure look like? And as I'm thinking about a potential subcommittee structure, reminded that all of that is wrapped up in the conversation about how we manage the group and how we operate. And I think one really helpful thing in this conversation is, for me, I would really appreciate consideration for us having some sort of a retreat or a session that we can really focus on the health, strength, and efficacy of the group as a group, and kind of a reset. What y'all think?
I'm just going to jump in. I am so in favor of that. And as a new member, and I don't know if the other new members feel the same way, but that just kept coming up as an idea. And I think Fleur may have even put it in the in the chat in the last meeting. But I think a reset and really thinking of how to sustain these structures could be something that would be nice to do in a retreat. And I felt some questions coming up regarding the report that I think could be nicely dealt with as a group about how we want to work together, how do we want to make decisions, how do we want to represent how we're making decisions. For those who can't weigh in, us understanding why and having some transparency around that, I think this could be a really nice way to do it. So, and I don't know if that could also be how we talk about the structure. Because I imagine at some point we might need to have an election, but I wonder if an election could even follow that once we sort of settle on a structure too. So.
Thanks, Karen. Other thoughts on this? I'm gonna be honest, I saw a lot of head nodding, but if we do it and y'all don't show up, I'm gonna be mad because it's just gonna be me with a table full of food.
Yeah, I agree. We should do it. I don't need to repeat everything Karen and you just said, but yes.
Excuse me, I don't know how to raise my hand on my screen, so buddy, would you mind, would whoever is responsible for it, mind pulling up that bill regarding weapons? I don't remember which number that was.
The one about what military grade weapons for municipal law enforcement?
Yeah, if I'd like to, if someone wouldn't mind giving me a look at that, I might have something to say on that.
Okay. Jeffrey, would it be okay with you if we pasted the link in the chat to give you some time to look at it? I'm just seeing we're close to time, and I want to make sure that people have a direction on the current conversation before we get back into details of legislation. Would that be okay?
I don't know what we're asking me to defer it to another time or wait till later or what.
If you are okay with us putting the link to that bill in the chat so that you can check that out, and then we can put you on the email for people who are interested in commenting on some of the active bills on policy. I'm sorry, I missed what you said. It was choppy.
I just said I will withdraw my request.
Okay, Jeffrey. Well, it is in the chat in case you change your mind, and we can also have the policy subcommittee, whatever we're forming as a policy subcommittee, take another look at that one as well, and we can reach it back out.
One last comment, is that okay? Suzanne, I wondered if you guys when help with doing that retreat, or if we we just formed this informal legislative committee right now, and that could help with like framing the retreat maybe. I don't know, I just feel so just lean on us or deputize us to help, and it would be good if there were maybe another member too. I don't know if you need help for that retreat part, or just how do we go about it?
I think yes, all assistance is appreciated. I think the biggest question we'll have to decide for ourselves is what kind of runway are we looking at? I would like to do it sooner rather than later, right? I mean, I'd like to, if possible, come into our March meeting already having done this. Maybe that's too ambitious, but I think there's a lot of enthusiasm in this group to move things. Are we all comfortable trying for something that's within a month?
I think that, go ahead, Sheila.
Are you looking at in-person type of retreat?
Yeah.
That's rough. That's rough for this month and this weather and this
That's
like
true.
and
And
it's just
and
it's a
some of us
bit
are down in the
busy.
Bennington and Southern in a
Like
month.
and then just to pull everything together, people arrange their schedules and for in person. And I don't know if you mean like in person, like try to take off of work in person or be there at night in person. Like if that like yeah, there's a lot of different variables. So to pull it off in a month, I don't know if you'll get the quorum or get the amount of people you want. But when you start talking a little bit more about spring or March, April, whatever, that's more realistic, to be honest with you. My opinion.
Okay.
And I hear the need for us to do some things, and maybe that means that we have to I mean, I know we've had this discussion about how many meetings do we have and all this, but maybe we need to call another virtual meeting. Maybe we need to have those subcommittees. Maybe we need to do something other creative or do something else in the interim of figuring out a retreat situation.
Thanks, Sheila. Other thoughts on this? I think that we would have to, we'll do well to articulate the purpose of that kind of a meeting, because if it's to say, let's figure out how we organize, how we operate, that feels to me like group structure and operational stuff, which I don't think we want to defer. But if that's something that we end up having to do at a meeting ahead of a retreat, then it makes me question, why do we, what else are we going to be getting out of a retreat? So would it be helpful if I sent around just a form that had a few of these kinds of questions, like times, dates, locations, days of week, sorts of things? Okay. You all know I get a little form happy. I'll try to keep it brief, but I can't make promises. And then I'm gonna ask that we impose a deadline, a due date. Our office recently learned the history of the term deadline, and so we've made a group agreement to stop using it. I'm going to impose a due date on this group on responding to that form by, is the end of this week too pushy? Okay. All right. So you will have that from me by tomorrow. And I'm just going to ask that you please fill it out by close of business on Friday. Okay. We are 7 minutes until the end of this meeting. I want to make sure that we have the opportunity to hold public comment. If there's anybody who's not a member of this panel who wants to address the panel, please feel free to do so. You can unmute and speak your piece, or if you're more comfortable, you can type your remarks in the chat. We'll be watching the chat as well.
Thanks, Susanna. I'll take a couple minutes. Thanks for the opportunity. I want to mention just a couple, Reverend Mark Hughes, Executive Director from Out Racial Justice Alliance. I just wanted to throw out a couple of other policy pieces. Just wanted to remind the RDAP of PR4, the Constitutional Amendment for Equal Protection, and also S301. S301 is a civil rights bill. H361 is a police oversight bill. I'm moving quickly intentionally. H382 is as you know, the data collection bill. I also want to flag that 529 is pretty kind of, it makes me nervous. So I know you went over it, but I just wanted to just resurface that. And as I dropped in the chat, on 741, Defender General, Judiciary, and State's Attorneys are testifying on Thursday. And I know those are all members of your group. And on 529, Corrections, Judiciary, and State's Attorney are testifying on Thursday on 529 as well. They're all a part of your group as well. And finally, I would just say that I really appreciated the deliberations that you guys had on the assessment, piece that you were contemplating whether it would be done legislatively or by rule. I thought that was pretty constructive. So thanks for that. I would just add to it that there seems to be a place for it in Title II. It seems like there might be some place that we might be able to land it in Title II. And also wanted to, and I'll drop in the chat just before I leave here, that the rules, the whole rules bit with the ledge is not, it's unlike any other rules process on the executive front, because it's all, within judiciary. So the rules committee is appointed. There's 3 from each cameral division, and then there's they do the rules every biennium. Some of you probably already know this, and so what you'd be looking at is joint rules. So I just wanted to make you aware of that. There is a, and I can just drop the current joint rules just for your review. That's them right there. And they're going to come, every session. Those joint rules are going to be contemplating those rules every session. And then I'll just leave it there. I think you can pretty much follow the breadcrumbs from there. But it was a good deliberation. And I just, from the public, I would say, I would agree with the folks who would be leaning towards the enacting it legislatively, because you are in a microcosm in the legislature, and you've got a very small number of people making decisions, not just on establishing the rules, but also, you know what I mean. Voting to, I lost my words. I think those are all the words I need tonight. Thank you so much for your time, and have a great evening. Great work.
Thanks very much. Thanks for the info and the citation references as well. And also, I think this group can occasionally use a pat on the back that we had a good discussion, so that was good. Anyone else who would like to address the panel who is not a member of the panel? Okay, I've waited the requisite number of seconds in silence. Let's review some action items before we close. So, what did we say we would do? I am going to put together a form about retreat planning. Now, you all are going to respond to that form by close of business Friday. And if you don't, you're not allowed to have an opinion and you can't complain. Just kidding, you can still complain. What else are we going to do? We're going to send out an email with everyone who put a name in the chat to do just some quick triaging of the policy items that we've identified. And those items are S193, H741, and H828. We are going to wait to hear back about a potential meeting this Friday regarding the impact assessment tool, so that the group can have more information about that. And what else did we say we would do? Okay. Is someone saving the chat? I don't know. I know we have a transcript going, but the chat is not the same as the transcript. I think that can just be manually done.
The chat, I believe, lives with the meeting. I just went back to 6:30 on the 13th, and I think I can go further back.
Okay.
Susanna, is it okay to ask a clarifying question?
Absolutely.
So Reverend Mark Hughes brought up a really good point about that there are many people who are on this panel who also sit on various different bodies who also testify to the legislature, separate from the RDAP hat. And so I'm just wondering if I missed it tonight, if those people either are not here or who they are. And I was wondering if we could make it a practice of our group that moving forward that people let us know that. So like being like, hey, I'm from DCF and on Friday or sometime this month I'm going to be testifying. I know I've heard it before, but I don't think it's been consistent, and I feel like we've had both of some people saying that they're going to testify and other of us finding out why didn't we know about certain bills or certain this or this or that beforehand, that certain members of our panel might have more access or information too. So I'm a little bit thrown off by that statement and kind of curious about in the discussion that we're going to have, and I'm recognizing that the meeting's over, that we recognize what are other people who are on this panel saying and doing, not with the RDAP hat on, but are on this panel. I need to know more about that.
Yeah, I really envision the standing item that we have for legislative updates as not just ORE talking at you all, but it being a more interactive conversation where we're hearing updates from all of us. So I also agree that I would love to hear more from member entities about what activity they have going on in the state house. It doesn't have to be long either. Hey, I was in Senate Judiciary on S123. We voted, or we testified against it because of this one particular reason. Done.
Yeah. Yeah, I think that's been pieces of information that we've been missing. And with new panel members, I think it's going to be less confusing if we are more transparent and understand those roles and more transparent about that information on the panel. So thanks, Susanna.
Okay. Sheila, if it's okay with you, we can maybe pick that up at a next meeting. In the meantime, I'll just ask everybody to consider your positionality and what you're able to do. I know not everybody here is necessarily a policy focused or a legislation focused person in their organization, so it may not be as easy for you to keep track if you're not the person. But let's come next time prepared to discuss that. I know we breezed through a lot of stuff in a time period that went by pretty quickly, at least for me, but is there anything else that has not been said that must be said before we close?
I just want to, sorry, I'm Maggie, she, her. I've been pretty quiet. I'm with the Rutland County Restorative Justice Center. I'm a panel member. And I don't typically testify, but every now and again I might get called to testify. And it's pretty last minute because it's typically from one of my funders. And so that can happen. It has happened, and I usually don't have more than 24 to 48 hours notice if that is going to happen because they pick stuff up so quickly. So I can like do my best to let folks know, but all of our stuff is typically restorative justice and not as of late has not been through the youth day. I'd say most of it's through the attorney general's office. I'm going to be there for a restorative justice AGO type day this coming week on Friday to talk about H566 with legislators. Pretty minor bill, but also important about expungement versus sealing. So I will be there talking with them, but I'm not testifying. And most people who are executive directors will also be there that day in the CJC, RJC realm. So there'll probably be between like 15 and 20 of us.
Great, thank you, Maggie. All right, everyone, look out for notes, look out for emails. Thank you in advance for prompt replies to stuff. And we will see you really soon.